Good morning. If it please the Court, Madam Chief Justice.
Good morning, Mr. Hirsch.
I'll be representing Mr. Burgess today. There are two main issues before us. One is whether Chapter 123, Section 15 is constitutional. The second, if so, was it constitutionally applied in this case? In other words, can the ruling of the Superior Court judge be sustained on any constitutional theory? I think the key to the first issue, whether 123A Section 15 is constitutional, we get the key to that question at page 19 of my brother's brief, where he says, nothing in the record suggests the existence of information helpful to the respondent which could not be retrieved due to his incompetence. Well, of course, nothing in the record suggests the information. Because he's incompetent, he's unable to put anything into the record. He is unable to affect the record, to augment the record, to change the record in any way.
Well, do you agree that this was a case in which it boiled down to credibility of witnesses?
I think it largely...
That's what the trial judge concluded.
Oh, it largely did. There was only one problem. There were only witnesses on one side. And
there was no medical evidence, there were no eyewitnesses?
Well, I would say on the second point, the lack of medical evidence strongly shows the weaknesses of the, of the Commonwealth's case.
So it boiled down to the credibility of the witnesses.
And how different might it have been if a competent Larry Burgess had been able to get up there before the court and say, Your Honor, say to the jury or the judge, this never happened. She has it out for me. I'll tell you why.
But didn't the legislature tell the judge to take that into consideration? And can't we, from the judge's findings and rulings, we can conclude that she did? Because suppose that the defendant had stood up there and said, and everybody knows what he'll say. He said, I didn't do it. And then the victim is lying, and here's why. And if she factors that in, but she finds that the witnesses were credible and that their testimony was powerful, as she said, she's factored in the assumption that he will testify and deny it.
Your Honor, your question is only, that answer is only good if we assume that under no circumstances, that nothing Larry Burgess possibly might have said, that no witnesses he could have advised his counsel about could have said anything, that nobody could have said anything that would have changed the result. And there is no way we can go along with that assumption. There is no way
I take
we
it
can
your
know.
position, Mr. Hirsch, is something along, had he testified along the lines, she might have found his testimony compelling. She might have found that when he was subject to cross-examination, that he withstood cross-examination extremely well, and that she had to, in a sense, weigh the credibility of two competing witnesses. It's possible that he might have given his attorney information that may have changed the basis of the cross-examination. I mean, I take it that's your point.
Yes, it is, Your Honor.
He might have brought in 40 bishops to testify that he wasn't there, in other words, had he been competent.
Plus 6 rabbis and an imam, Your Honor. It's entirely possible.
The root of the problem here, it seems to me, is that this is not a criminal case. So the question of incompetency is an interesting one and certainly a compelling one in the criminal context, but this is not a criminal case.
But as I pointed out in my brief, Your Honor, incompetency is not a doctrine that's limited to the criminal arena.
Well, pretty closely limited to the criminal arena.
I would disagree, Your Honor. We have the Hinnant case to begin with.
That's a very different case. It's a rendition case.
Yes, Your Honor, and it's a case where the defendant has far less input into what goes on and can say far less to change the result than is possible in...
Right. What else beyond the rendition context?
Well, there's the juvenile context. Now, what we have
I
here...
just didn't hear the word you
The
said.
juvenile context.
Juvenile.
Which is also, we are told, not the same as the criminal system in many different ways. We've backed off from...
Yeah, but it's sort of a quasi-criminal proceeding, at least. Talk a little bit more about perhaps the Chapter 123 proceedings, the civil commitments, where people are, I suppose, effectively incompetent in many of those cases. we use the beyond a reasonable doubt standard of proof. They're allowed to cross-examine their witnesses. You have somebody who may be civilly committed. I know it's for 6-month periods, over and over and over again repetitively.
Well, you're talking about 123 as opposed to 123A.
That's right. But in 123, the people are committed. It could be for the rest of their lives. And we still have to prove that they did something that causes them to constitute a danger. And both statutes are remedial, 123 and 123A.
The big difference between this and 123 and the statute at hand in 123, 123 doesn't have this kind of predicate requirement of a finding that a specific kind of crime occurred. And that's the basic difference. 123A is so different from other commitment statutes. In no other such kind of case is there the requirement that...
But the problem is, it seems to me from your perspective, is that in the 123 cases, you oftentimes get a person who is being committed who is incompetent, and we still proceed against them.
Much as we do in 123A cases under Nieves. Yeah. But that, again, is a very different situation. In other words, we can bring in witnesses in a 123 case to say the respondent committed X crime against so-and-so. And certainly the defendant will be unable to answer those charges being incompetent. But that's not the key to the case. The fact finder can say, well, I don't believe that he committed that specific crime. But there's other stuff here in the record showing that this man is a danger to others or is a danger to himself. Here, the whole key, the whole reason for the Section 15 hearing is proof of a particular act that is of a particular nature.
But isn't that, you're viewing that as a weakness in the statute. Can't you look at it as a strength? It's a procedural protection?
But no more than any other trial is a procedural protection. And we don't allow trials of people for the same kinds of acts when they're labeled criminal. Under cases such as Speck versus Patterson, we should be no more forgiving of attempts to lock up people who are incompetent based on their having committed specific acts.
But as Justice Cordy was saying, isn't it a benefit to the defendant to be able to focus, or for his lawyer, to be able to focus on, in the 123A proceedings, a specific event, a specific incident, whereas in the 123 proceedings, there's a much broader scope?
One could just as easily say that it's a benefit to have a jury trial in a criminal case for an incompetent person where his lawyer can challenge all of the evidence. You can call it a protection, if you will, but our Constitution has protections against such protections.
Isn't part of your argument that in every 123A case dealing with a competent person, there has to be this proof beyond a reasonable doubt in a criminal trial of the events that form the basis for the sexually dangerous person part? And here, that whole predicate is very different. And then when you add that to the fact that once adjudicated an SDP, removing that adjudication, it seems to me, just on the face of the statutes and the way that they operate, is very much more difficult than a 123.
Yes, Your Honor, I would agree, and that's why I've argued that this statute, Section 15, violates the Equal Protection Clause. We have the old standby Jackson versus Indiana, which tells us you can't have a more lenient commitment standard for one class than for another. Secondly, we have the Americans with Disabilities Act, which tells us...
How can that possibly apply here? This is not a program.
I would encourage the court to look at Tennessee versus Lane, which specifically mentions civil commitments as one of the grounds for ADA coverage. Lane says it. It's not my invention. It's there.
In this sense, I mean, so what are you suggesting? That if someone is mentally ill, they shouldn't be committed because that would be a violation of the ADA?
I think there are different ways in which Lane might and might not apply.
Mental illness is a requirement here, has to be proven.
Your Honor, first of all, the basis for this kind of legislation is largely to cover people who would not be considered traditionally mentally ill and would not be committable under 123. So,
But they have to prove a mental illness and
a mental
dangerousness.
abnormality or personality
Yep.
disorder.
Mental abnormality or personality disorder.
Before we get to that issue, the basis of the proof of the mental abnormality disorder, the thing that the statute is trying to save the citizens of the state from, is repetitive action by people who have mental disorders that indicate the likelihood of sexual reoffense. The only way we get to that threshold, the only way anybody could say anything about Larry Burgess's likelihood of committing a new sexual offense comes from the allegations that he had been committing them over a period of years against the victims in this case.
There was certainly a process designed, a hearing, an evidentiary hearing. Yes, he couldn't fully participate, but that doesn't mean there wasn't a process directed specifically at that point where the
No
government...
one says there wasn't a process. The question is whether it's a constitutionally adequate process. And under Cooper versus Oklahoma, granted a criminal case, but every word of what they say there applies to this case as well. Competence to stand trial is rudimentary, for upon it depends the main part of those rights deemed essential to a fair trial, including the right to effective assistance of counsel, the rights to summon, to confront, and cross-examine witnesses, and the right to testify on one's own behalf, or to remain silent without penalty for doing so, citing
Mr. Hirsch, may I ask you a question? I know it's highly theoretical because we don't have the statute, but I take it implicit in your argument is that if the state felt that this was a person who should be subject to the same level of incarceration as somebody who had been found guilty of a sexual crime, and instead of saying there has to be a finding beyond a reasonable doubt that he committed these acts, which then become the predicate, that there be in essence a parallel, a proceeding rather parallel to 123 that says there's nothing on which one can go. There's no finding that there's a predicate crime that's been convicted, but you have to look at, as you look at any person with any kind of abnormality, as to whether or not he's likely to commit sexual offenses.
No, I don't think so, Your Honor. I think the answer to that is provided by your decision this Court's decision in in McLeod, where the Court said that there has to be a predicate criminal conviction in order to narrow the pool of people eligible for this act. Again, keeping in mind that this is not the typical civil commitment statute, that this is, as Justice Kennedy said in his concurrence to Kansas versus Hendricks, one of those places where we have to be really careful because we're combining aspects of criminal justice and mental health law, where we're dealing with the use of criminal acts as the basis for civil commitment.
If this defendant, forget about the SDP proceeding for a moment, if he were committed as an incompetent defendant, mentally incompetent defendant under Chapter 123, the Commonwealth would every 6 months have to, or I guess initially 6 months and then a year, would have to proceed against him by showing beyond a reasonable doubt that he was mentally incompetent and constituted a risk to others. In order to keep him committed, he would be incompetent in that proceeding as well.
Yes.
Why should the state be allowed to proceed against him in that proceeding as an incompetent, but not in the SDP?
Well, first, there's a limit to the time during which the state is allowed to do that. He's exceeded that limit. The only reason we're here is that Larry Burgess has gone beyond the time when he legally can be held as an incompetent. He is no more. He's exceeded that, And rather than let him go, as would happen with any other criminal defendant who was incompetent over that length of time, the Commonwealth has now said, we got another way to keep him locked up. Now,
Is that the primary aspect of the difference between the two cases, would you say?
that's one of several different aspects. Massachusetts does not require, as some states do, a finding of the person having likely committed the specific act in order for him to be held as an incompetent. It merely requires a finding of risk to the community, and we need not pinpoint the risk in that situation, as must be done in this case. So it's basically a different thing. The court has the power to protect the community from an incompetent person who is alleged to have committed a crime. They've run out of the time to do that.
Well, except that they could still proceed against him under Chapter 123.
Section 8, if they could.
Yeah.
If they could.
Well, they
Right.
would have to prevail at a hearing.
Exactly. And that would not be a hearing to determine whether he was...
He had committed the predicate act.
I'm sorry?
It would not be a hearing to determine whether or not he'd committed the predicate act.
Thank you, Your Honor. Under these circumstances, I would just add that my brother relies on the Greenwood case upholding a similar statute in Washington, but Greenwood specifically says they're not analyzing the case under Matthews versus Eldridge's three-part due process analysis. The second of the three parts is the one crucial here, the risk of erroneous deprivation of that interest. How can the risk of erroneous deprivation of that interest be any different under Section 15 than it is in a criminal trial? It cannot be. And not only is it... Thank you very much.
Thank you, Mr. Hirsch. Mr. Greenbaum?
Good morning, Your Honors. May it please the Court. I'm Stephen Greenbaum, representing the Commonwealth in the Northwestern District. I had two sort of fundamental points to make, and I did want to respond to the last comments by counsel regarding the Commonwealth seeking another way to lock up the respondent, which I don't believe is an accurate or fair statement. But I would suggest that the principal conceptual flaw I would suggest in this argument is a focus on structure rather than purpose. The Section 15 hearing is a preliminary screening hearing in 123A to serve that due process purpose of, and this is reducing the risk of an erroneous deprivation of that liberty interest by essentially requiring the Commonwealth to meet the same proof required in the criminal setting of proof beyond a reasonable doubt in a criminal setting. The fact that structure is the same as a criminal trial does not mean that the constitutional prohibition on criminally trying an incompetent person should apply here. The focus should be the purpose of this proceeding, and the purpose of the proceeding is screening. That it serves two purposes. It serves that due process purpose. It also serves the purpose represented here of narrowing the pool of people who are subject to commitment under 123A. Incompetent defendants who have committed sexual offenses can't be committed unless the Commonwealth crosses this threshold. And I believe that this focus on structure also is perhaps revealed in, actually I seldom refer to reply briefs, but in the respondent's reply brief he addresses the points raised by the Commonwealth regarding the Section 17 hearing in the regular 123. In Chapter 123, a person who's incompetent and been petitioned to be dangerous has the opportunity to petition the court and raise a defense, not of incompetence or insanity, but the defendant can raise a defense. This is in Commonwealth versus Hash, and the Commonwealth has to prove in the normal, the non-SDP incompetence setting that there's substantial evidence from which a fact finder could conclude beyond a reason, could convict someone. That hearing in Hatch, the purpose of that hearing is screening. The defendant, when he attempts to suggest that...
But, there are consequences of the screening, correct?
The Section 15 screening?
Yes. I mean, the consequences of this are essentially incarceration, correct?
No, the consequences are the case goes forward to the SDP commitment trial. There's no consequences other than...
But that's the predicate.
Yes. Yes, that's a requirement the Commonwealth has to pass, the same as in Section 17.
Any other situation where we make a finding of fact that a crime has been committed where a person is incompetent? Where they cannot, because of their incompetence...
I'm not aware of one. But again, what I wanted to complete that other point. The difference between Section 17 and Section 15 is no different in purpose.
Would it make any difference, for example, if the legislature had said, we have some allegations made by some people on the basis of which we've sought indictments. There's been a finding that he's incompetent, and what we want is a trial judge or some other fact finder just to listen to the complaining witnesses.
I'm not sure if you're talking in terms of a 123A commitment or just...
No, 123A. No right of cross-examination, because we're really just trying to determine...
Well, I'm not sure that any screening procedure is required. Jackson versus Indiana and Hatch itself both refer to the fact that an accepted principle is dangerous, incompetent defendants can be civilly committed.
Yeah, no.
There's no constitutional requirement that these sort of preliminary fact-finding procedures be conducted. It's recommended. 123.17 has a
I understand that, but we have a civil commitment proceeding, correct?
Right. Yes.
Which has been held.
And I believe the
upheld.
legislature could have suggested a proceeding that you're describing apparently. Some sort of hearing where the judge I'm not sure exactly what your hypothetical is, but it could have suggested that, and this court might have found that that's not sufficient procedural due process protection. I'd suggest that Section 15 is the maximum protection.
Well, if you're inviting the court to say that we could find there was no, that there might be some level where it isn't sufficient procedural due process, then I wonder why the core piece, which is the right of a person to testify and to cross-examine, is not at risk here. In other words, why can't you just do a 123 proceeding if there's a risk of dangerousness in the community?
Well, Mr. Burgess was committed under 123 previously.
Right.
In 1998, he was committed. And at a certain point in time, the treatment center, not the state hospital, petitioned for his discharge, claiming he no longer satisfied their criteria for major mental illness. There are different criteria for SDP. If in fact the Commonwealth, and the case law is there, Commonwealth isn't required to use a specific means. The fact is that Mr. Burgess satisfies the criteria for 123A, and at least according to the state hospital, no longer satisfied the criteria for commitment under 123. He's sexually dangerous, or at least the Commonwealth asserts he's sexually dangerous, and we have legislation that in hand to commit him to protect the public from that danger. He may not satisfy the criteria for Chapter 123. Therefore, we're going using the mechanism laid out by the legislature to pursue commitment of him because he's dangerous. That is why.
So I take it.
I don't see that we're limited, that because 123 exists, the Commonwealth must use that mechanism. And in Chapter 123, there is no mechanism like this. An incompetent defendant who's dangerous gets committed. In fact, the Section 17 hearing, which might allow him to have his criminal charges dismissed, does not guarantee that he'll be released from his dangerousness commitment. The two are independent. So unless this court is going to want to undo Chapter 123 and suggest that that is also unfair because there's no procedure in place to test the underlying facts of the charges in a 123 case, then I'm not sure where there's a problem here with the criminal trial type proceeding that's been put in place for Section 15.
I take it that if he is, I don't think there's been a Section 12 through 14 proceeding yet, has there?
Probable cause, the procedure, probable cause was found. We went to Section 15. The court concluded beyond reasonable doubt, and the case has been stayed since then.
Okay.
He has not even been evaluated by examiners.
Assume for the minute that he is committed under Section 14. I take it that if he thereafter, under Section 9, is released at some point, that he would not have to register as a sex offender. Is that right? Because he doesn't have a criminal conviction.
I don't believe so. I don't believe the sex offender registration statute takes this into account. It
Well,
requires
can I just
convictions.
ask you about that? The last sentence of Section 15 says, any determination made under this section shall not be admissible in any subsequent criminal proceeding.
Correct.
The sexually dangerous legislation proceedings are not criminal proceedings. So what's the basis of your saying that the fact that he has been found beyond a reasonable doubt in a proceeding, let's assume that we agree with you, that affords him full due process, that couldn't be used by the Sexual Offender Legislation Board?
I believe the registration board statute requires a conviction. This is not a conviction. It may be a finding beyond a reasonable doubt, but it is not a criminal conviction. In the absence of a criminal conviction, there's no requirement to register. Someone who's got a continuation without a finding, who's basically pled, submitted to facts sufficient for a finding of guilt on a sex offense, is not required to register under the sex offender statute either, because they don't have a conviction. So it just wouldn't apply. It may be a loophole, although I would suggest that, as far as I know, that there are not very many people who fall in the category of Mr. Burgess.
Are there any other people who fall into this
I
category, to your
believe
knowledge?
in another county there is a petition going with an incompetent defendant like this with no predicate convictions, and in my district, I don't know which county, we just filed a petition against another individual who has only been found incompetent to stand trial for sex offenses, who has no conviction. So as far as I know, there are only 3 cases, and this one has gotten very slowly as the farthest. I don't know where the other case has gone, if it's gotten to probable cause. I did want to address this final portion of respondents' argument regarding something about the time limit and another way to lock up Mr. Burgess. My understanding of Chapter 123 is that you can either petition, or when the earliest parole date comes up for the maximum time you could get on your offenses, the criminal charges are dismissed. Mr. Burgess was charged with rape in 93 or 94. The earliest parole date back then was 15 years, which means that in 2008 or 2009, the criminal charges against him will be dismissed. So to the extent there's some claim that this is some sort of sneaky way to petition to hold Mr. Burgess beyond the time the criminal charges are there, that's just inaccurate. And then furthermore, the petition was filed in 2000. We're here 7 years later for reasons we don't need to get into, not attributable to the Commonwealth. But the petition was filed well within the time when those criminal charges were pending. And also, the court didn't get into, and the respondent didn't get a chance to get into his applied challenge regarding what actually happened here. And one fundamental point I see here is in attacking the judge's findings regarding the effect of the causes of Mr. Burgess's incompetence on the outcome. I believe that's solely a factual finding for the judge. Respondent's argument seems to suggest there's some sort of legal standard to be met there that I'm not sure what it is. I don't believe that there's a legal standard. It's not like a required finding. The judge merely made factual findings based upon voluminous records and her observations during the hearing as to what it appeared to be the effect, how his incompetence changed, if at all, this proceeding. And to the extent that there was an argument or perhaps a suggestion that this was not like a trial, I would suggest reading the transcript. This reads very much like the transcript of any child sexual assault trial where the defendant doesn't take the stand, and that is often the case. If you have a defendant who doesn't present well, you don't put him on the stand. And in this case, if you read the records and the judge's findings, which are supported, it wasn't that Mr. Burgess couldn't testify, that he didn't have a memory of what was going on. It's that his presentation would have been very poor because he decompensates under the pressure of trial. Her findings are well supported by the record. If there are no other questions, I'll rest on my
Thank you,
brief.
Mr. Greenberg.
Thank you.